deploying arbitration as the preferred form of dispute resolution mechanisms helps businesses to also save money that could have been lost if they had utilized a protracted dispute resolution mechanism.
Yes.
Disputes are an inevitable part of every business and commercial relationship. However, you still find out that founders and business owners alike often miss out on the importance of having a proper dispute resolution mechanism to resolve their issues whenever they arise. Good day, everyone. I'm Okule Obina, an associate of the Trusted Advisors Legal Practice, and today I am joined by Miss Ayola Sembanjo, the head of department of the Conflict Management and Dispute Resolution Department of the Trusted Advisors Legal Practice. You are very welcome, ma.
Thank you very much.
All right, ma. So, in your experience, why do you think brilliant CEOs sign contracts, but somehow they leave out the dispute resolution clause to a copy and paste method? Do you think it's a lack of foresight or they don't know what's at stake?
Well, in my opinion, I think it's a combination of both.
Okay.
This is because most of the time, CEOs and founders get so much engrossed in the prospects and profitability of a business transaction such that they lose focus
Okay.
of what may ensue if the transaction goes bad.
Okay.
And so when they lose that focus, they become unprepared and they fail to secure their positions in the event that the transaction will go bad.
All right. So, what mechanism can they explore to resolve their commercial disputes whenever they arise?
There are various mechanisms that businesses can explore to resolve their commercial disputes.
Okay.
We have the traditional approach, which is the court system.
Okay.
This is where parties file their claims before the courts. The court hears the evidence of parties and then decides on the matter by giving a judgment. We also have alternative means of resolving disputes, which we technically call the ADR, that's alternative dispute resolution.
Okay. So, these ADR mechanisms, what are the various forms of ADR mechanisms that businesses can explore to settle their disputes?
There are various ADR mechanisms that businesses can explore.
Okay.
We have mediation, we have the conciliation, we have negotiations, we also have arbitration.
Okay. So, of all these mechanisms you just listed, which one do you think is most suited, or rather, more appropriate for businesses to adopt in the event of commercial disputes?
I think the most appropriate form is arbitration.
Okay. Why arbitration?
This is because of the advantages arbitration affords the parties.
Okay. What kind of advantages does arbitration have?
I'll mention just about a few.
Okay.
The first one is the fact that arbitration is a party-driven system.
Okay.
This means that the parties get to coordinate the conduct of the arbitration proceedings.
Okay.
And part of the things that parties get to do is that they get to choose the arbitrator. The arbitrator is the one who decides over the matter. He sits in the place of a judge over the matter. The parties present their cases before the arbitrator and the issues in dispute, and then the arbitrator hears the evidence of the parties and the submissions and arguments and gives a final decision, which is called the award.
Okay.
Another thing is that which I would call part of the key elements of an arbitration agreement, is the fact that the parties also get to choose the seats of the arbitration. The seat of the arbitration is a jurisdiction, which refers to the country in which the arbitration proceedings will be conducted. When we're talking about international arbitration. For domestic arbitration, it refers to the state in the country in which the arbitration will be conducted. Parties also get to choose the venue, that's the place in that country or state where the proceedings will be conducted. The parties also get to choose the language. Where you have cross-border disputes and different nationalities and languages are involved, the parties get to choose and agree on the language, which language will govern the arbitration. Parties also get to choose the rules, procedural rules that will govern the arbitration proceedings.
Okay. Nice.
And must I also mention that in choosing an arbitrator, one of the advantages in getting to choose an arbitrator as well is that the parties are able to choose an arbitrator who is an expert
Okay.
in the field. And this means that this arbitrator is knowledgeable and skilled in the area of dispute.
Okay. That's nice. So, what other advantages are there?
The other advantages I would say are one, also the fact that arbitration is a private and confidential proceedings. Now, being private and confidential, it means that the brand and image, the parties get to have a brand and image protection.
Okay.
When disputes arise, most of the time, trade secrets and sensitive information is revealed in the course of the proceedings. Because of the privacy that arbitration affords the parties, all the secrets are confidential. They are not exposed to the public. And we know that if some of these information gets exposed to the public, the competitors of either of the parties may use these information to cause or bring about reputational damage to an organization or a business. So arbitration completely eradicates this possibility.
All right.
The third advantage is the fact that arbitration saves time. This implies that parties have control of the time within which they can resolve their disputes. And this invariably guarantees cost savings to the parties, which translates to the time value of money. This means that when businesses encounter high value commercial disputes, the time saved in resolving the dispute enables the parties to invariably save the high monetary investments and claims that are tied to these transactions. In essence, businesses are able to avoid the adverse and negative economic implications in terms of things like inflation, which may result in the devaluation of the financial investments or currencies involved in these transactions. So, deploying arbitration as the preferred form of dispute resolution mechanisms helps businesses to also save money that could have been lost if they had utilized a protracted dispute resolution mechanism.
This has been so. I can see the advantages of arbitration now. So, if you had a word of advice to business owners and founders in a company, or in-house counsel of a company, what would the advice be?
My advice to business owners is that they should consult the services of a dispute resolution expert to draft a robust arbitration clause in any commercial in any commercial transaction. For any commercial transaction. And whenever a dispute arises in any commercial transactions, they should consult the same dispute resolution experts to initiate the arbitration proceedings.
Oh, wow. That seals the deal. Miss Ayla, this has been nothing short of an insightful, wonderful, and educative conversation with you. Thank you so very
You're
much.
welcome.
Yeah, so we advise businesses to take into consideration all salient points that have been mentioned during this conversation. This will help businesses to be adequately protected in the event a dispute arises. Thank you so much for your time.